Conducting reference checks can be one of the most important steps in the selection process. Since past performance is often the best predictor of future performance, references allow you to talk to past supervisors in order to determine if the applicant being considered is suited for the role. Reference checks help you confirm information on the candidate's application form, resume, and through the interview process. You will gain greater insights into candidates' skills, knowledge, and abilities from someone who's actually observed the candidate perform. Some employers mistakenly believe that it's unlawful to ask for references. That's simply not true. Others fear that reference checking is a waste of time because former employers won't reveal a candidate's weaknesses or speak openly about the individual's job performance. Finally, many hiring managers simply don't know where to start, so they base their hiring decision on the interview and their gut feelings afterwards. Additionally, costly court judgments have prompted many careful corporate attorneys to limit what human resource professionals can say about past employees, even good employees who would benefit from the exchange. In a Society for Human Resource Management poll on reference checking, 98% of employers said their organizations would verify dates of employment for current or former employees. 68% said they wouldn't discuss work performance. 82% said they wouldn't discuss character or personality, and 87% said they wouldn't disclose any disciplinary action. Hiring a candidate without checking references is like having a loose cannon on the deck of your ship. After all, conducting an interview will simply give you the candidate's side of the story. Who better than a previous supervisor to balance out that story and provide some insights from a third-party managerial perspective? So I'm here to tell you that quite simply, reference checking is good. Employers are advised to familiarize themselves with certain legal guidelines, however, including those on the state level as they relate to reference checking. Let's take a deeper look. Former employers frequently hesitate to cooperate when asked to provide information about an individual's employment to would-be employers. This resistance is usually founded on the fear of being sued by past employees for giving less than flattering references. Accordingly, many employers only verify dates of employment in an effort to mitigate any legal exposure to a defamation of character charge. Although it's understandable that employers want to err on the side of caution, they may be overly careful and fail to recognize that a great deal of information can be legitimately and legally imparted from former employers. Since apprehension of being sued for defamation prevents employers from seeking or providing employment-related information, understanding 12 key elements of defamation could help to alleviate this concern. Number 1. Defamation may occur when one person makes a statement about another that's implied to be factual, but is instead intentionally false. Number 2. Statements made with a reasonable belief that they are true are generally treated the same as true statements. Number 3. Defamatory statements may be either oral or written. Number 4. The person to whom you're providing information must have the right to know it, e.g. a potential employer. 5. Disclosed information must be employment-related. Number 6. The information you provide must be truthful, even if it's negative. Number 7. Information must not be communicated with malicious intent to do harm. Number 8. You may not volunteer information, even if it's employment-related. Number 9. The information you provide may not be of a personal nature. Number 10. If a former employee gives a prospective employer a false or damaging reason for the employee's termination, or gives the discharged person a false basis for the discharge, and the applicant repeats this information to a prospective employer, then this self-disclosure may result in charges of defamation. Number 11. Disputable opinions or statements are protected by a limited privilege. That is, such communications must not be malicious to be actionable. And number 12. Employers are advised to seek legal advice regarding their state's statute of limitation for filing charges of defamation. Next, think of the boundaries of qualified privilege as legitimate inquiry plus truthful information plus absence of malice equals qualified privilege. Now let's talk about what that means. Employers are further protected by the common law principle of qualified privilege. This doctrine is premised on the public policy that an exchange of information relative to the job suitability of individuals is in the best interest of both employers and the general public. Consequently, if such information is defamatory but without malice, it is deemed privileged. This privilege is not without certain limitations, however. The information must be provided in good faith and in accordance with the questions asked. For example, if a prospective employer asks about a former employee's ability to work unsupervised, the voluntary statement that she had a problem getting in on time is not protected, even if it's true. Also, information about an individual's private life should not be offered unless it's relevant to work performance. Moreover, former employers should ensure that the information is being provided to the appropriate party and is relevant to the requirements of the job. Failure to comply with any of these conditions could eliminate the protection provided by qualified privilege. This document does not protect statements that can be proven to have been made with malicious intent. The number of states with reference checking laws is increasing. These laws protect employers that provide good faith job references of former and current employees. This added protection enables employers to give and receive references that go beyond the typical play it safe policy of verifying dates of employment for former employees. Even with such legal protection, however, the trend is to proceed cautiously, providing only documented information that can be easily defended in court that's job-related. Despite the degree of protection afforded to former employers by the common law doctrine of qualified privilege and individual state laws, many still fear liability and hesitate to provide references. The result has been the proliferation of lawsuits based on negligent hiring and retention. The only effective defense against charges of negligent hiring is a complete investigation of all job-related facets of the application's employment and background prior to employment. Background checks of previous convictions and driving record violations may be deemed appropriate depending on the job. This presents quite the dilemma for employers. Former employers can be sued for defamation when providing improper references, and prospective employers can be sued for negligent hiring and retention if references are not properly checked. Some employment experts suggest a possible solution, requiring job applicants to sign waivers, thereby relieving former employers of liability if applicants are not hired due to unflattering references. Now let's take a look at giving and getting references. Some job applicants exaggerate or even lie about qualifications and experience in the job application process. The best way to uncover this kind of puffery is to ask some former employers for the inside story. Former employers are often reluctant to say anything negative for fear that if they speak frankly, they may be hit with a lawsuit for defamation. They're hesitant to do anything more than verify the former employee did in fact work for them and give dates of that employment. This can make it hard to get an accurate picture of a job applicant's history. As mentioned, it might be helpful to send the former employer a copy of the applicant's signed consent to full disclosure of employment information. So let's take a look at the following guidelines that provide direction for getting references on your candidates. First, have a policy. Conduct reference checks on all applicants at a given time in your selection process. Tell applicants in the interview that you'll be checking their references. Have the applicant sign a consent form for you to check references. Ask for 3 to 5 work-related references from the applicant. Have the applicant assist in the process by informing references that you're going to be calling. Check references by phone when possible, and evaluate negative references fairly. Some tips for conducting that phone call reference check include: start the reference by introducing yourself, ask the reference if they have time to talk, start with simple verification type questions, then ask open-ended questions that are behaviorally based, and finally, ask questions and follow up to the interview. Common questions asked in reference check include: what were the individual's job responsibilities and salary? What the individual was successful in their role or organization, why or why not? What was it like to supervise the person? Was the person a valuable member of the team? Why or why not? And what unique skills did the individual bring to the organization? Other questions can include: what were his or her strengths or weaknesses? Was the person ever disciplined? Do you think the individual is suitable for the job? Why did the person leave the organization, and what else might you need to be aware of? Now let's switch gears and talk about giving references. Whenever one of your employees leaves, you will have to decide what to say to other employers who call for a reference. The decision is pretty straightforward if the employee leaves on good terms. You and your former employee can come up with a mutually agreeable statement and explain it during the departure process. Or you can simply tell the whole glowing truth to any prospective employer who calls for a reference. But if the employee was fired or had challenging performance issues, you face a more difficult task. Let's take a look at a few guidelines for giving references. When a potential employer calls for a reference, you might feel trapped between wanting to tell the truth and fearing a lawsuit if you say anything unflattering. Unfortunately, this fear is not founded. Plenty of defamation lawsuits have been filed over negative references, and even if your former employee can't successfully prove that you've defamed him or her, you will have to spend precious time and money fighting that allegation. So here are some tips to help you give reasonable references. First, have a policy. Have a written release that gives you permission to provide references. Warn a difficult employee that your reference won't be good. Stick to job-related facts, being honest with accurate and documented information. Don't volunteer information or answer questions that aren't asked. Rather, focus on answering the questions that are asked. Avoid extremes, don't be spiteful or give false flattery. Designate one person in your organization to give references and keep a record of the references you give. Now, be free to go give and get great employment-related references.